My name is Thomas Hoeren. I'm responsible for LDE, and we are talking this morning on the DSA, the Digital Services Act. Let me show you my slides. My slides are there. So the DSA, Digital Services Act of the European Union, is unique piece of legislation. You don't find anything like that in other states or continents. It's based on the E-Commerce Directive. I hope you remember the difference between directive and act. Act is a regulation which doesn't need to be implemented nationally, while a directive is made for implementation by each member state. So there is a danger of having various implementations. The DSA was made in 2022 and entered into force already in 2024. So it's in force. So since 3 years ago, the 19 platforms in Europe have been subject to the DSA. The purpose of the DSA is to protect consumers and their fundamental rights, to find a standardized legal framework for the liability of online platforms, and create more transparent rules for algorithms and online advertising. When you have listened to me, you will consider the first target point as dubious. Protection of consumers. Nobody is talking about consumer in the directive. So the question is it good justification for regulating that matter? It's a question of the legislative competence. So to talk about consumer protection is a reference to Article 114 of the Amsterdam Treaty, of the Fundamental Treaty of the European Union. But it's not enough simply to mention fundamental freedoms of consumers in order to have just a jurisdiction. So the question of legislative competence is still rather unclear. The obligations of platforms mentioned in the DSA have nothing to do with fundamental freedoms or fundamental rights. So open question is, has the Commission mentioned the correct competence reference for the DSA? Nevertheless, the DSA targets intermediary service providers, and there are several types of intermediary service providers mentioned. The pure access services called transmission services, then the caching services, then hosting services, then online platforms. That is the traditional differentiation people do in Brussels to distinguish the different types of service providers. When you see the list, you immediately have the view there's something missing, and in the last minute, only added during the trilogue negotiation, somebody said, oh, we have forgotten the online search engine. So the Commission started to amend the draft and quickly integrate the search engines. So, in addition, it's not only necessary to be an online intermediary service, but to have a significant link to the EU. So, your third country service providers are only bound by the DSA if they have a significant link to the EU. This connection can be established by a permanent establishment within the EU, but the DSA also wants to regulate services from third countries, especially the US, and therefore we have to apply the market price principle, which you already know from unfair trade law or the GDPR. So we need to define where is the relevant market for a service when the market hits at European clients, EU users. Then you have a general link, and then you are bound by the DSA, even if your company has a seat, for instance, in the United States. There are certain indications which can be used to define and find a general link to the European market, such as language, currency, or top-level domain, as well as the supply of products to the EU. On the other side, the mere accessibility of a website is not enough, but if you have indications that the website has a target EU, then you are in. And we're going to the center of the DSA. The center, in fact, is a system of liability for platforms. So the DSA defines a general concept of liability for this intermediary service. It applies horizontally. That means based on the former E-Commerce Directive, the DSA applies to all topics of liability, whether it has to do with trademark law or unfair trade, to defamation law, everything we talked about in summer term. There are 3 exceptions. One is copyright law, that is regulated in some member states by specific copyright liability acts, like the Urheberrechtsdiensteanbietergesetz in Germany. Then second exceptions, that's made by a case which we are talking about in 2 minutes, called Russmedia of the ECJ. When it has to do with data protection, the GDPR applies, and the GDPR has separate rules for liability. Then third exception, consumer law was expressly taken out of the system of liability of the DSA. So these are the general concepts. This is a general concept, and added is as well some kind of public law obligations to build up a model called notice and take down. It's coming from press law. So in Presso, we have the feeling that if somebody is complaining about a platform intermediary, he could send a notice to the intermediary. The intermediary informs his customer that somebody is complaining about the website, and then the notice is the website is taken down. That's the idea, and therefore we have specific public law obligations. I just mentioned that the GDPR was a separate regulation for data protection of personal data. And in that area, we have separate liability rules. So the Court of Justice had to decide on the 2nd of December 2025 in the Russmedia case whether we can apply the notice on takedown to data protection, but data protection was taken out, is regulated by the GDPR, and this is far more important than the DSA. So that's a very important decision to understand the relationship between DSA and the GDPR. So I mentioned the E-Commerce Directive. The E-Commerce Directive was a very old directive from 2000, and this directive already had a system of separate platform liability. So it was a model regulation for the DSA, but it's not valid anymore. So what is the idea? The idea is blocking at the host, so at the platform. The platform is has liability for a lot of matters which have to do with internet. The substantive law is not regulated in the DSA at all. That's only a matter of national law. So what is legal and illegal in trademark law or unfair trade law? That's the topic of these national laws. In the DSA, it's only regulated the procedural specifications, like how can I report to the platform provider? Does the platform provider has a duty to take state reasons? Does he need to implement internal complaint management, and so on? So I already explained to you that we have certain model situations which have to be distinguished. At the end of winter term, I explained the content provider is not regulated at all by the DSA. He has to bear the full liability for his own content stored on his own computers. Then we have the access provider. He is not regulated by specific liability duties. There's Article 6, and he's taken out of liability. So an access provider like telecom, like Wi-Fi, cannot be made liable. I explained in winter term as this liability is still open for discussion because national courts have tried to say that there is a cascade situation. That means when you want to sue, you first have to sue against the content provider. If he doesn't stop the illegal content, then you can go to a host provider under the DSA. And if that doesn't work, you can go to an access provider and sue him for stopping access, wherever that works. Is that model of cascades, different types of liability, still applicable under the DSA? Nobody knows. And as I said, in the DSA, they are talking mostly about host providers. That is somebody who stores the content of a third party on his own computers. People like YouTube, eBay, Instagram, whatever. That is all this platform. That was the purpose of the DSA, to regulate that and to combine it with a public law specification what host provider has to do with a complaint. So the first thing he has to do is he has to wait. He doesn't need to take care and has no proactive obligation to search for content which is perhaps illegal. So he is waiting for the reports coming in. How these reports have to be made is described in Article 16. So then, if he then stops certain content, he has to explain why and how. And then he has to provide an electronic and free of charge complaint organization according to Article 20. The complaint can be made based on illegality or incompatibility with the general terms and conditions. And then he has to apply a mechanism called out-of-court dispute resolution. So he has to find a mechanism for deciding about a complaint, especially in a case where the customer says, I don't make any mistakes, my content is not illegal at all. So that leads to dispute resolution. This is very, very important. So, no further structure. We have to distinguish between intermediary service in general, hosting service in particular, an online platform very in particular, and a very large platform as the top of liability in the area of intermediary services. There's a system of graduated duties, so general obligations for all intermediary services, and then additional specific obligations for hosting services, then more extensive additional specific obligations for online platforms, and then the highest rank for so-called VLOP, very large operating platforms, which have more than 45 million average monthly active user. Here you see a German slide with this system of graduated duties. Who is a very large open platform, It's very bad for a company to be named in VLOP. So VLOP is, for instance, Alibaba, Amazon, Apple, Booking.com, everything which you know, which is fun in the internet. We even have the category of very large online search engine, that's Bing and Google Search. Some companies have complained of being not VLOP. You can sue against the categorization as VLOP. For instance, Zalando has tried to say that, but they had no luck. There's you can ask for a court proceeding in deciding whether you are VLOP. So Zalando, for instance, is VLOP. Let's now talk about the graduated duties. There is a general obligation of the intermediary services, the general intermediaries, that includes the access providers. Even they are intermediaries and they have general obligations, such as the duty to name a contact point in the EU. And if they have their seat outside the EU, they need to define a certain legal representative. They have to have transparent and user-friendly general terms and conditions. So they need to inform their customers on restrictions on the use of data. Furthermore, they have to inform once for a year on the way they moderate content, the number of blocking orders, the number of complaints. That's very important. The next category, hosting providers. A hosting provider is an intermediary service that consists of storing information provided by a third person as the third person's request, cloud storage, web hosting, marketplace. So what he has to do is to grant these public law obligations, so to provide a way to complain about the legality of the third party's content and to check the content quickly and to indicate whether it's legal or not legal. If it's illegal, then you have to stop it. That's all for hosting. And even more important, if you are an intermediary providing hosting services and you store and disseminate of information to the public. So, for instance, hosting and public-facing distribution. Then you are an online platform. Typical examples: social networks, video sharing platforms like YouTube, marketplaces like Amazon. So, excluded from the liability of online platforms is interpersonal communication services like WhatsApp or Signal, and services where the dissemination to the public is not the main feature. It's very complicated to define that. So excluded are, for instance, services which are not meant to disseminate information to the public, like intranet, like services, or purely private sharing context. So these companies have even more duties, like they have to provide an internal complaint handling system, they have to provide an out-of-court dispute settlement, they have to make a special treatment for so-called trusted flaggers. But so a company is known to be really reliable on making complaints about legality as a so-called trusted flagger, and they have a right to be handled with priority. So their online platform has to provide measures against misuse. Here describes the trustworthy flaggers model, and they have an obligation to stop repeat offenders who are known to regularly disseminate illegal information on the platform. They must be blocked for an appropriate period of time. That's the same if you have obvious uploads of illegal content. The providers have to stop and block the service for a reasonable period of time. That's is a model coming from France. France had a system called Hadopi. So if you're complaining about a person frequently or obviously storing illegal content, the provider of a platform has to stop this person from using their services. Online platform, that's very important, have an obligation to stop dark patterns. What is dark patterns? That is described in Article 25. That is a system where users are misled, manipulated, or otherwise significantly impaired or hindered in their ability to make free and informed decisions. So it's a very broad and nebulous concept, but that's a new way how in Europe it is described unfair trade. So if you're thinking in the German categories, we say that is paragraph 1 of the UBG. So you are not allowed to do things which are misleading customers in their way to get free and informed decisions. Article 25 in particular interfaces covers interface techniques that repeatedly prompt users to make a certain choice or to present options in a non-neutral manner or to create artificial frictions for decisions that are less favorable. As I said, that's very, very broad. And in this moment, some courts are thinking about the effect. When we talk about two decisions, in Germany, the Bamberg Higher Regional Court said that is not a matter of the DSA. We have in Germany the Gesetz gegen unlauteren Wettbewerb, Unfair Trade Act, and we use the values integrated in internet business under the DSA. as a background for applying still unfair trade law. In Amsterdam, a court has decided differently concerning Meta's algorithmic feeds, where they think this is a special new category for applying directly Article 25. So that's the first case we have where some European court applied the DSA directly as a new model of unfair trade law. So you see the effect of Article 25 when you see the decision of the European Commission, which has found in February that TikTok infringes dark patterns and uses dark patterns because of its addictive design. So they are bound by the decision to change their whole structure of showing videos because that is a strong push for users to keep running, scrolling, and rewarding users with new content. That is deep patterns, according to the European Commission. Then we have 26, which prohibits intransparent advertising. So that's is the pendant of Section 5 of the General Unfair Trade Act in Germany. So intransparent advertising is forbidden. So Article 26 is a long regulation, for instance, saying that information should be clearly classified and recognizable as an advertisement. You should explain on whose behalf the advertisement is displayed, and you should display and provide information about the main parameters used to determine the recipient. And then third element, providers of online platforms need to take care for minors who are users of a certain platform. So every platform accessible to minors have a general obligation to assess risk of this access of young people. Perhaps you remember that in Australia they start to say that children under 16 are not allowed to use social media. So that's all. Now I'm coming to the final category, the harsh, very large platforms. So platforms which have more than 45 million monthly active users within the EU are called VLOP, and they have to assess in advance systematic risk arising from the use of their platforms as regulated in 34. That means they have to take care in advance about possible risk of using their VLOP. That is a very harsh rule because the sanctions ultimately are stopping the VLOP. So if the systematic risks are not adequately addressed and compliance failures persist, informal enforcement might escalate, and at the very end, the European Commission can even say, please stop the VLOP. So it's a tool for prohibiting eBay and Meta, Instagram. So that is a problem as well for the US government. Perhaps you remember that at the Munich Security Conference in February 2025, Mr. Vance was delivering a speech sharply criticizing the DSA. He says it's suppressing free speech, and the EU Commission is kind of commissar and accused them of Soviet-style censorship. So there's a harsh criticism of the US authorities of these obligations for VLOP. So there are even more obligations to have an annual inspection at their own expense and to appoint an independent compliance officer. Then in 42, to give data access for vetted researchers. I will explain that in a second. So they have to open their advertising archive and explain how many commercial companies are giving money and spending money for advertising. So, for instance, Amazon must make their advertising archive open with detailed information about online advertising publicly available. So that's the reason why the ECJ and said Amazon is liable for having their archives open to a free access by the public. More obligations have to disclose relevant parameters of the decisions algorithm used for the provision of content, and they have to build up a repository using RPs, and these information has to be made available to the public in the form of researchers. It's called scraping. So you have different methods of scraping. You have the overall universe of legitimate research. So make research and checking and tracking the sites and the apps, so even outside the DSA. Then you have Article 40, subsection 12. You have to give information to researchers about systematic risk. And then you have Article 44. There is a situation where you provide information via scraping. So VLOPs have to give away to researchers empirical research as part of platform regulation. Web scraping can be especially used as a research method, extracting especially personal and non-personal data. So, and you have a duty as VLOP to provide access, not to the world, but only to vetted researchers that are researchers which are checked and classified as being very good and trustworthy university researchers. So you are checking first who is calling for access to this data, and if you are sure that this is a trustworthy person, you can give the data away. So, next topic, enforcement. The DSA is enforced independently, on the one hand by the European Commission for the big companies like VLOPs, by non-VLOPs, small companies, by national DSCs. So, national DSCs are established. DSC stands for Digital Services Service Commissioner. That's made in Germany by the Bundesnetzagentur, a very powerful state authority which has to develop national guidelines, receive all the reports which are necessary, including a report on systematic risk, and develop standards. It receives all the information from platform on infringement, on inspecting platforms and interviewing platform staff. It checks the offer to users of a complaint system and builds up European expertise. So as I said, the enforcement is done by a coordinator at national level and a European committee. The European Commission has the right to intervene and to check VLOPs. They can investigate, they can do decisions on interim measures, they can even install penalty payments and fines up to 6% of the annual worldwide turnover. So that's really harsh. 6% is quite a lot. What is not been done is the Commission planned to have a new competition tool before the DSA. So they were aiming at tackling structural competition issues as well. So the power of Google, Amazon, Meta was a matter for criticism within the European level. So they were talking about a tool which allows regulators to intervene proactively, break up market power, and impose structural remedies to restore fair competition. This was not included in the DSA, and certain minor questions are now being dealt by the DMA, the Digital Market Act. So, how is the DSA being enacted by the member states? It doesn't need to be implemented. So it's only a question to decide about the national authority controlling the DSA. So it's done nationally. Here you see a long list of organizations in certain member states. In the two search engines below, you find even more information, but that is until now the final checklist for saying who is what in the area of the DSA. In France, it's a combination of two authorities working together. In Spain, it's the same situation. In Austria, we have the Kommunikationsbehörde Austria, Austria. They are checking everything. In Germany, we have enacted the DSA, the Digitale Dienstegesetz, and we have the Bundesnetzagentur, who is doing the job by, for instance, checking complaints, coordinate everything, cooperate with other national DSCs, and to cooperate with the European Board for Digital Services. We still have one act which is missing, the Digital Violence Act Germany, because Germany thinks that the DSA is not enough. There should be more on regulation, especially when it has to do with gender-based violence and sexual violence online. So there is the idea of requiring online service providers to prevent preventive and reactive measures tailored to identify forms of violence, but it's still in stop. Is not dealt with in the moment by the German government, and we are waiting what they are doing. At the end, I'm making a reference to the TikTok case of February this year. So, because that's the first case where a VLOP was attacked by the European Commission for not taking care as to dark patterns. So they are missing risk mitigation Article 35. They don't take care for dark patterns, and they are intransparent as to their recommender system. So there is a violation of Article 34, 35, and 25. So TikTok can go to the ECJ now and complain about the Commission and stopping the investigations by the Commission. We are waiting what they are doing. So I hope you liked my quick survey on the DSA. If you have any questions, do not hesitate to contact me. Have a nice day. Yours, Thomas Hoeren.